All right, well, welcome everyone to the third in our series of seminars funded by the Balliol Interdisciplinary Institute and with support from the Oxford Internet Institute on privacy issues in genomic medicine. Over the last couple of sessions we heard something from the scientific point of view, and we also heard something from the legislative point of view, and today we're very happy to have with us Mark Taylor from the University of Sheffield, who will give us some insights into some of the legal and ethical issues involved, particularly in the question of what kinds of consent frameworks are appropriate for this rapidly changing world of genomic medicine. Mark is Senior Lecturer in Law at the University of Sheffield. He's also Deputy Director of the Sheffield Institute for Biotechnology, Law and Ethics. And he's been very active in recent years in a number of advisory committees to government on questions relating to confidentiality. He's very recently the chair of the Confidentiality Advisory Group. He's also been invited by Dame Fiona Caldecott, who will be speaking to us next term, to join an independent information governance oversight panel. So Mark is obviously very well connected in the various organizations which are certainly going to have an influence, a large-scale influence in the UK at least, on the way in which private information, and particularly genomic information, is treated, and the way in which people can be persuaded, induced to give consent for various kinds of uses over and above the kind of traditional uses of clinical information. So thank you, Mark, for joining us on this not very pleasant evening. Thank you all for coming. I'll turn it over to you.
Thank you for inviting me. Thank you for coming out in a not very pleasant evening. And thank you for inviting me to take part in what is a very interesting seminar series. Unfortunately, this is the first one I've been able to get to, but I sincerely hope it isn't the last. I want to be able to attend at least a few more, because I think with the range of speakers you have, you are in a position where you can approach some really difficult questions, and a series of difficult questions you have on your programme, from a number of different perspectives, which is going to make it interesting from the audience's perspective if you can see the same issues considered consecutively by different people who are approaching it from a slightly different perspective. So when I look down the list of the questions that you are intending to tackle, the first thought is, wow. The second thought is, well, how could I possibly contribute towards that? What kind of issues that you are hoping to consider might I have something to say in relation to? And I think I pulled out two issues that you intend to address during the course of the seminar programme that I hope I might be able to offer some thoughts on that would be of interest and maybe useful with regards to prompting discussion and maybe even developing your thoughts as you move through the series. One of the questions you wanted to ask is, well, what's the state of the current regulation and legislation in this domain? Who has control over genomic data and related health data and its uses? And that's something I want to try and address to some extent. And then towards the end of the list of things you want to consider, you asked the question, was Scott McNeely right to say privacy's dead? And privacy's dead, get used to it. And if so, what's the impact likely to be on public attitudes towards and expectations of personal genomic privacy? And I hope during the course of the presentation to address, at least in some part, both of those questions on the programme. As Arthur said, my own perspective is as an academic. I am currently chair of the Confidentiality Advisory Group for the Health Research Authority, and I am, during the course of the presentation, to say something about the Confidentiality Advisory Group. I want to make clear now, and I will make clear again later on, I'm making these comments as an academic with some understanding of the work of the group. I'm not here to represent the views of the group, and nothing I say should be taken as representative of the views of the group or the Health Research Authority. I'm speaking very much for myself as an academic with an interest in this area. So what I want to do is try and work through three topics, issues, questions. The first is to try and say something about the relevance of public interest. I'd say my focus at the moment is more upon the issue of public interest and how it intersects with different consent frameworks, rather than the focus being on the consent frameworks themselves. But hopefully looking at it from the perspective of public interest will itself be interesting. I want to say, what has public interest got to do with access to genomic data, control over access to genomic data in the current legislative and regulatory framework. And I'm going to suggest that in this framework, currently, the public interest operates as both a justification for access at times, and that's the kind of use of the public interest we might be more familiar with, where we justify disclosure in the public interest. But I also think the public interest operates as a restraint on disclosure and controls over access at times as well. And I'm going to try and explain what I mean by that, and try to link this, of course, to research access to genetic data. My focus initially, for the first half of the talk at least, is going to be research access to genetic data and controls over research access to genetic data without patient consent. So what's the current regulatory framework that permits or controls access without consent, and what role does public interest play in that as both enabler and constrainer? I want to offer you my view, my insight, my opinion on how CAG, the Confidentiality Advisory Group, who I'll explain what the role of CAG is in this framework. I'll say how I think they currently approach the public interest question. What do they think is the public interest when they are trying to work out whether disclosure is in the public interest? How do they reach a kind of decision? It's a difficult thing. We all recognise the many myriad ways in which different people have tried to define and explain what the public interest is in different contexts. How do CAG approach it in practice? Then, very much taking off and stepping away from the CAG hat, I want to say, okay, how might we develop that concept of public interest? How might we defend a particular approach towards understanding the public interest in access to genetic data for research purposes? And might that apply not only to access without consent, but might that also apply to access with consent? And might there be a case for the public interest test being applied to disclosure, even if that disclosure is taking place on the basis of a patient's consent? Okay. And they're the three kind of headings. And I said patient at the end there, and I should make absolutely clear, my focus is on data which is gathered during the course of providing care and treatment. So my focus is upon when you get access that has been gathered because somebody was in a clinical environment. And that's what I'm talking about primarily, and that's what I know more about than other things, which isn't so I know a lot, it's just relatively speaking.
When you say genetic data, are you
Yes.
talking about whole sequence or medical? What do you have in mind when you say genetic data?
I'm at the moment operating with whatever concept of genetic data this program is intended to address.
So it could be broad sequence. Or
It could be.
a genetic abnormality.
Yes. I have to say that within other work and the different conversations that I'm happy to have, I take issue with the notion of genetic exceptionalism. I think that genetic data can be meaningfully described in a whole raft of ways, which actually makes it quite difficult to draw qualitative distinctions between genetic data and other kinds of medical data. So for my purposes, I'm not going to get hung up on a particular definition, because I don't actually think that a particular definition is defensible within a broader context of medical data. So no. No, I'm absolutely not. So I can please rest assured on that particular point. So I'm talking about genetic data that's collected as part of routine care, and by that I should have said, I mean any data about genetic architecture, whether at whole genome sequence level or SNP or any point in between.
And how that manifests in terms of physiology or behaviour or the
yes, because we might say that's genetic data. Am I determining genetic data about you now when I determine you have a Y chromosome? So if I record that you are a male, am I recording genetic data about you? Is that what you mean by phenotypic characteristics?
Sure, but that the genetic data is only meaningful insofar as it manifests in some condition or some phenotype.
We only care about it because it has significance at phenotypic level. Primarily, within a healthcare context. We care about it for other reasons, for social reasons, if we're doing paternity testing, when suddenly genetic information can be massively significant, even though there may be no phenotypic. Okay. So, yeah. The question which you ask in the programme, who has control over genomic and related health data? And because I was taking my cue from that question, I'm just looking at this very broadly. And we might want to consider later in discussion whether there's any good reason to narrow the definition, but I don't have one for you now.
You get questions like the observational data where a doctor can tell by looking at someone that they have a genetic condition, and does that get classified then as genetic data?
Yeah. I attended a conference once and somebody walked up to me and said, "Oh, you must be here representing the Marfan Syndrome Association." To make your point. Which is also to make the point that genetic data is not necessarily accurate. Whether it's gathered at the level of the analysis of the nucleotide level, or whether it's gathered at phenotypic level, there's an error rate in... Anyway. So when we talk about genetic data, are we necessarily talking about accurate, or can we be talking about a perception of genetic data, whether that's accurate or not, which I think further complicates things when people start making assumptions based on a belief that a particular phenotypic characteristic is related to a genetic characteristic, which is itself related to something else of value. Right, to give you an example of that, there was a thing in the newspaper, one of these nonsense stories in the newspaper a little while ago about how the ratio of finger length was related to sexual orientation. Okay. Nonsense, I'm sure. Yeah, but the point is, somebody reading that might think, oh well, actually I can observe something about somebody's phenotypic characteristic, that tells me something about the genome, that then tells me something which I attribute some kind of significance to. And that was an example of the kind of thing I meant. Of course it's all nonsense, but at what point do you cease to regard that as genetic data because it's nonsense? Or do you accept that a perception that it's genetic data is sufficient to justify control in a particular way? Sorry, we seem to have come off the rails early. I'm very happy to just have a discussion, but I'll press on for now and we'll come back. But yeah, I'm very happy to take questions as we go through and have a discussion as we go through. So, focus is upon research access genetic data collected as part of routine care, and I think it is important that we draw an attention to the differences between collecting data, genetic or otherwise, during the course of providing care and collecting data specifically as part of a particular research project. There are even if one is seeking to get consent, as Genomics England intends to do in relation to the collection of genetic data of 100,000 NHS patients, the data being collected during the course of the delivery of care and treatment, the intention is to get consent. But I don't think the opportunities for consent are the same as the kind of opportunities for consent that exist in a project such as Personal Genome Project. And I think one needs to recognise there are certain constraints upon the context in which consent can be got, because if you're turning up to receive care and treatment and somebody asks you if you're willing to participate in a research study, already there's a dynamic there. You're going to get help and somebody asks you if you're willing to help others. There's a different dynamic there to if you voluntarily seek out a research project to get involved with. And within the context of a busy clinic, there are just many different kinds of constraints that apply to the gathering of consent for purposes which extend beyond care and treatment. I want to make it clear that I'm talking about that particular context because I think it's significant at the end when I intend to suggest that context makes it particularly appropriate to apply, I think, the constraints put upon getting consent within the context of clinical care make it particularly appropriate to apply a public interest test to disclosure, even for research purposes, even if that disclosure is consented. Because I think the process of obtaining consent for that use within a clinical context is constrained by a number of factors. Okay? Okay. So, I want to start by talking about the first one there, the relevance of public interest, where there is no explicit consent. So I want to try and discuss with you and clarify with you the role that public interest currently plays in the regulatory framework that establishes the conditions under which genetic data or other health data can be disclosed for research purposes without consent. Now, the situation in the UK has changed post 1st of April 2013 with regard to the collection of patient data for research purposes. As of 1st of April, the Health and Social Care Information Centre in the UK got new powers to require health professionals to disclose confidential patient data to the Information Centre to be used for purposes which extend beyond patient care and treatment, so that the Information Centre might make such data available, for example, for research use. That's a significant change because it's the first time that we've had a body with the power to mandate the disclosure of confidential patient information from GPs and other healthcare professionals. Now, I'm not going to say very much about that because there's a specific statutory basis for that. But I do want to point out that the disclosure to the Information Centre is of identifiable information, but the Information Centre itself will do all the linkage and aggregation in-house and will not make available to researchers identifiable information, usually. The exceptions to that rule, that the Information Centre would not make available identifiable information, genetic data or otherwise, to researchers or other, the exceptions to that rule are the same exceptions now as they were before the Information Centre had the power to collect it. So we can talk about the conditions under which identifiable data can be disclosed, and we are talking about disclosure then directly from a healthcare professional or disclosure from the Information Centre if the Information Centre have collected identifiable data under their new powers. Does that make sense? Are there any questions about that? Okay. So what then are the constraints placed upon the disclosure of identifiable data for research purposes? And what does the public interest have to do with establishing the conditions of such disclosure? And can it happen without consent? Those kind of questions I want to address. Let's look, first of all, at the Data Protection Act. Okay? The Data Protection Act itself does use the term public interest a number of times. It uses it, for example, in Section 32 when it's talking about exemptions to certain requirements of the Data Protection Act for journalists, and journalists can disclose identifiable data if it's in the public interest, broadly speaking. I mean, it's more complicated than that, but I'm not here to talk about journalism, so I can get it a bit wrong. When it comes to Section 33 of the Data Protection Act, which is the one which concerns research exemption and research use of identifiable personal data, and if we're talking about genetic data, and if that genetic data is identifiable, then it is personal data within the definition of personal data contained within the Data Protection Act. If we look at Section 33, there's nothing in Section 33 itself which talks about public interest. It is, however, the case that you can use identifiable data, including genetic data, for research, medical research purposes without getting consent under the Data Protection Act, and you are able to use identifiable genetic data for medical research purposes without getting consent because, although it doesn't say it on the face of the Act, because it's considered to be in the public interest. The reason I say that is because the Data Protection Act itself, as I'm sure many of you know and may well know better than I, implements the Data Protection Directive, Directive 95/46 EU. Article 8 of the directive establishes a general prohibition on the processing of sensitive personal data, which it then recognises may be rebutted in a series of circumstances, the first being explicit consent. But further down the list, there is recognition that the general prohibition on processing of sensitive personal data, which would include health data, may be rebutted in cases where the processing is necessary for medical purposes. The list of medical purposes contained within the directive doesn't include research. When the directive was implemented into the UK law, medical research was added on to that list of medical purposes. The only way that the UK could justify including that is if they took advantage of another section within Article 8 which allows member states to make further exceptions to the general prohibition for reasons of substantial public interest. So it can only be because the UK considered it to be of substantial public interest that the UK Act listed medical research within Schedule 3 of the Data Protection Act, which is the schedule which you look to determine whether some of the conditions of lawful processing are satisfied. So processing of identifiable data is lawful without consent under the DPA because research was included within that list in Schedule 3, which UK could only have done if the UK considered it to be in the substantial public interest to do so.
Processing or disclosure?
Processing, for, which would include disclosure, but any use for medical research purposes can be, satisfying one of the conditions within Schedule 2 and 3 isn't sufficient, but it is necessary. So unless you are able to satisfy one of the conditions in Schedule 3, you are not able to demonstrate the legality of the processing. If you are able to satisfy one of the conditions, you have satisfied the conditions of Schedule 2 and 3, but one would need to satisfy other legal requirements before you could demonstrate the legality of the processing. Yeah?
The public interest isn't quite enough for free disclosure. Yeah.
Under the Data Protection Act, processing for medical research purposes is sufficient to satisfy the conditions of Schedule 3.
You mean there is no privacy, get over it?
No. No. The first data protection principle requires fair and lawful processing. Lawful requires satisfaction of conditions set out in Schedule 2 and 3 amongst other background legal considerations. Fair requires transparency. So you have to tell people what you intend to do with their information, unless you're not able to do so in practice. There are qualifications to this, but generally speaking, you have to tell people what you intend to do with their information.
How far do they need to understand it?
You have to make
There's a difference between telling them, but most of the people won't even understand what you're doing with the data, what the implication would be.
No, I don't disagree with you, but the responsibility upon a data controller is to provide the information. When you scroll through the privacy notice on the next piece of software you install, or the next time you purchase something from Amazon to get to that button that you can click as quickly as possible, it's not because it's not because you couldn't understand, it's because you choose not to. A data controller can't take responsibility for whether or not you read the information that's provided to you. So the responsibility upon the data controller is to give you the information. They're not responsible for whether or not you understand it, but they are responsible for providing it to you in a way that you could understand. So if you look at the Information Commissioner's guidance on privacy notices, they do talk about making information accessible to people, and their guidance is to use a layered approach whereby you don't have a privacy notice that's 12 pages of A4, 12 sides of A4, font 10.
In legalese.
In legalese. So good practice guidance steers people away from that kind of thing. But if you're looking at what the legal responsibility is, the legal responsibility is to provide information. Okay. So I'm not going to say any more about the research exemption because I'm looking at the clock and I'm looking at you, and I realise that the chances of me actually getting to the end of these slides are which is a good thing, but it means that I'm not going to linger on things which I don't need to linger on. I'll try and get to some of the more interesting points later. The point here I wanted to make is that processing for research purposes of identifiable data, processing for medical research purposes, it is important you include that medical research modifier. Processing for medical research purposes without consent is lawful insofar as it satisfies one of the conditions of Schedule 3. Doesn't mean that it's lawful full stop, because there are other considerations, and I'm going to move on to consider one of them, the common law duty of confidence.
Mark, can I just ask
Yes, yeah.
Does medical include pharmaceutical research?
The term medical is not defined within the definition. Sorry, that was redundant. The term medical is not defined. And so it would be open to a court, the interpretation by court, but yes, it would include pharmaceutical, as long as it was related to the development and improvement of pharmaceuticals rather than cosmetics or trying to, conduct research for the purposes of marketing using identifiable data that you got from a pharmacist for the purposes of marketing, then not all processing by a pharmaceutical company would fall within it, but it could do if it was sensibly described as medical research. Okay, so that's the data protection bit. Moving on then, as well as having to satisfy the requirements of data protection law, which I've barely scratched the surface of, but we can pursue if you have an interest. I rarely find an audience champing at the bit to know more about data protection law, but you might be the exception that proves the rule. So moving on, the other legal requirement that needs to be satisfied in this context is the common law duty of confidence, because information provided to a healthcare professional who is providing care and treatment, and you're disclosing personal information to them for the purposes of receiving care and treatment, they are receiving that data in circumstances where they are expected to treat that information with a duty of confidence. Now, there's lots, again, that might be said here, but let me distill the essence of the common law duty of confidence to two words: no surprises. What the court is trying to ensure is that when you provide information to somebody that owes a duty of confidence to you, they do not do anything with that information that you would not reasonably expect them to do. It comes down to questions of reasonable expectations of privacy. That notion is itself distilled within the NHS Code of Confidentiality into the idea of no surprises. So doctors should try and avoid doing things with data that a patient would be surprised to learn they were doing. Now, by and large, we assume that a patient that presents for treatment expects the data they provide to be used for the purposes of delivering care and treatment, either directly or indirectly. If people need to have access to this data to support their care, then through requesting the care, you are understood to have consented impliedly. Through the act of presenting for treatment and asking to be cared for, you are understood to have consented impliedly to the data being used in ways that are necessary to deliver and support that care and treatment. So, using confidential data for the purposes of providing care and treatment falls within the notion of reasonable expectation. But there is a question as to whether or not patients would expect you to do anything else with that information. Because if they're providing it to you so that you can care for them, why would they expect you to do anything else with it? Now, one of the ways in which you can adjust their expectations and you can demonstrate that actually that individual had a reasonable expectation that you would do something other than simply provide them with care and treatment is consent. And doctors are advised to seek consent from patients if they intend to use identifiable data for any purpose other than the provision of care and treatment. So, whilst the Data Protection Act itself doesn't require consent, and the section within the UK Data Protection Act which allows processing for medical research purposes as an alternative to explicit consent, it doesn't push people towards consent and allows public interest processing. Common law duty of confidence does seem to expect that you will ask people or otherwise make clear to them that this is what you intend to do with their information and give them an opportunity to object if they have any problem with that. And they could object for any reason whatsoever. Now, this idea that before you can use data for any purpose other than provision of care and treatment, you have to ask people. There is a history to that, but I won't go into it unless you're interested. It goes back to cases around Bristol and Alder Hey, and the fact that if you go back a century, medical information was being used for all manner of purposes because doctors thought it was appropriate to do so, and doctors' understanding of what it was reasonable and appropriate to do so seemed to, at least some doctors, shall we say, rarefy, and certainly parted ways with what the general public expected their data and tissue to be used for. As a result of the furore that followed, the GMC changed its guidance to doctors and said to doctors, if you're going to be using people's information for anything other than care and treatment, you really need to be telling them and asking them if that's okay. When the GMC revised its guidance, there was the early part, around 2000, they revised it a couple of times, but they revised it once around 2000. There was then a reaction to that because people said, research epidemiologists, people that cared about public health, people that cared about cancer registries, said, if you're going to insist that we only use data for purposes beyond care and treatment with explicit consent, you're going to kill a whole range of really worthwhile activities, because we just can't get consent from the population if we want to do a population level epidemiological study. We can't get consent from, well, people in a whole range of different circumstances to do with numbers, to do with rare conditions where actually, although you might be able to approach people for consent, if only one or two people say no, then the study's pretty much kiboshed because you need full ascertainment. So they reacted to this idea that you could only do research and use data for further purposes with explicit consent with quite strong and merited concern. Government reacted. Section 60 of the Health and Social Care Act allowed the Secretary of State for Health to lay regulations which set aside the common law duty of confidence for medical purposes, including medical research. The regulations that were laid are known as the Health Service Control of Patient Information Regulations 2002. Now, the Health Service Control of Patient Information Regulation 2002, laid under Section 60 of the NHS Act, Section 60 of the Health and Social Care Act, sorry. Section 60 of the Health and Social Care Act 2001, which led to the 2002 regulations, that provision became Section 251 of the National Health Service Act 2006. So we now have power in Section 251 of the 2006 Act to lay regulations, and rather than refer to the Health Service Control of Patient Information Regulations 2002, we talk about Section 251. So it is now possible to get support under Section 251 as a shorthand for these regulations. It's anomalous because Section 251 is a 2006 section, the regulations are 2002. It's one of these quirky little things. We have provision within law for the common law duty of confidence to be set aside for research purposes, which means that explicit consent is not needed in order to disclose. And here we're talking specifically about disclosure. We're not talking about processing per se, although it's used primarily to enable individuals to disclose identifiable information without patient consent in circumstances where disclosure would otherwise be a breach of the common law duty. So there is power to use genetic data without patient consent, without breaching the common law duty of confidence, if an application has been made under Section 251. An application has been made under the Control of Patient Information Regulations. Now, these applications can be made in relation to research and non-research. Used to be the Secretary of State that made decisions in relation to both research and non-research. Now, since 1st of April, it's the Health Research Authority that makes decisions on research access, and it's still the Secretary of State for Health that makes decisions in relation to non-research access. Now, at the time this went through Parliament, there was concern about Whitehall having the power to set aside the common law duty of confidence and to allow use of confidential patient data for medical purposes, including research but extending beyond research. One response to that was to set up an independent advisory group. At the time it was known as the Patient Information Advisory Group. Subsequently it became known as the Ethics and Confidentiality Committee of the National Information Governance Board. When the National Information Governance Board, the NIGB, was abolished 31st of March 2013, the advisory function transferred into the Health Research Authority. So we now have the Confidentiality Advisory Group that advise on the use of these regulations. And these regulations allow the common law duty of confidence to be set aside and for personal confidential data to be disclosed for research purposes in circumstances that would otherwise constitute a breach of confidence. Namely, to be set aside and allow disclosure without patient consent. Okay? Go on.
I'd be interested to have a couple of concrete examples by which that would be generally considered advisable. You know, because it won't be all circumstances, so
no.
Have a sense to have maybe an example or two examples.
National diabetes audit is one example where national audits, when data is used within the context of an organisation for audit purposes, so we're checking the quality of use is appropriate, that's done within the context of implied consent. But the idea that you can disclose confidential patient data out of an organisation to a third party that may be being employed, contracted by HQIP or whoever to deliver a national audit, Can that data be disclosed without breach of confidence? Section 251 is relied upon to ensure that disclosure for those purposes doesn't constitute a breach of confidence. It allows, it's permissive, it's not mandatory, so it allows disclosure, it doesn't require it. Another example would be where researchers want to get access to retrospective data collection. Data's been collected for healthcare purposes. It was collected a long time ago. They want to go back and they want to analyse it, maybe link it with some other data that's now become available. There is no way in which they can contact these individuals because the names and addresses aren't up to date. Maybe they're not sure how many of them are still alive. They are, if they were to contact them, to contact them would require disclosure of more identifiable information than the researchers actually need. But can they use the data that is there for research purposes? Well, they can under if they apply under Section 251. And those that hold the confidential data can make it available to researchers to use without worrying about whether or not, in disclosing it, they've breached their common law duties. One more example, because it's a different type of case, consent for consent issues, where researchers want to approach individuals to invite them to participate in studies. I was going to relate this to genetics, just one genetic example is UK Biobank. UK Biobank wanted to write out to an awful lot of people that fit a particular demographic profile and invite them to participate in UK Biobank. How do they get the names and addresses? The names and addresses are contained within medical records. They want certain limited amount of demographic details to ensure they're writing to the people that they want to invite. They got access to those names and addresses using 251. The conditions of support are that you can't do the research or can't do the thing you're trying to do with non-identifiable information. You have to need identifiers, and people get regularly challenged on that. And you can't do it with consent. You have to be able to demonstrate there is no practicable alternative to relying upon regulations. But if you can demonstrate that you can't do it with consent and you can't do it using de-identified information, then two of the major hurdles have been overcome. The other hurdle, which I wanted to talk about particularly this evening, is the group need to be satisfied that disclosure is in the public interest. So you can get access to identifiable data if the other conditions are satisfied and the group is satisfied that it's in public interest. So we do get involved in some controversial matters, not least of all with NHS England at the moment, but that's for another day. Section 251 is used at times to support genetic research, and I've already given you the UK Biobank example, but not so very long ago I was abroad and I returned to this headline, sale of personal gene data condemned as unethical and dangerous, and it related to a story about data that was genetic data being collected by the NHS that was then going to be made available to third parties for research purposes. Now, Section 251 is not the only way in which disclosure of identifiable data can be lawful, but it is a significant and well-travelled path. It is one of the primary ways in which those that wish to disclose identifiable health data, patient data, for research purposes can satisfy the legality of the disclosure. So, disclosure of genetic data that has been gathered by the NHS for research purposes can be lawful if it's done under Section 251, Health Service Control of Patient Information Regulation 2002. I'm using Section 251 as shorthand. When it hits the headlines that disclosure of genetic data in identifiable form is unethical and dangerous, and it could only, and the way in which it could be done is through the support of the Confidentiality Advisory Group, as a member of that group, of course, you become a little concerned that the reporting may not be entirely accurate. Some might say sensationalist, others might say wrong. And unfortunately, an awful lot of the reporting in this context is very misleading and doesn't do anything to support public trust and confidence in the security of the health records, which I think is what's unethical and dangerous, the reporting of it, rather than the practice, certainly as currently undertaken. So how does Confidentiality Advisory Group go about trying to determine whether disclosure of confidential patient data is in the public interest or not? Well, we try to identify what the risks are to what we consider to be the public interest in a confidential healthcare service. So how sensitive is the data? How valuable is the processing that's being proposed? What kind of healthcare improvement is it intended to bring about? Recognising there is a public interest in improvements in healthcare. We try very hard to ensure that the research or whatever the other purpose is, the non-research purpose that's being undertaken, we try very hard to ensure that it's undertaken in ways that respect both the public interest in a confidential healthcare system and the public interest in improvements in healthcare. And on those occasions when they come into irreconcilable conflict, we can't have our cake and eat it. When we say something has to give, we try very hard to ensure that the reasons we have for privileging one public interest or public good over another are reasons that we think the public would accept as reasonable. One member of the group describes this as the Humphreys test. He asks me regularly whether I'll be comfortable going on the Today programme defending the decision we have just made, although I have to say we make recommendations, the Health Research Authority make decisions, whether I'd be comfortable defending the recommendation we've just made. More regularly though, we ask ourselves whether or not the patients concerned would accept as reasonable the position we have taken. And that may be because we have decided to disclose or recommend disclosure, or because we have decided to recommend that data is not disclosed. Because we shouldn't fall into the trap of thinking that all patients want the data to be locked down and never used. Some patients would actually be quite angry if they found out that certain kinds of research wasn't taking place. So if ever we recommend that disclosure doesn't take place, we also need to consider whether or not we could look the patients in the eye and offer them a reason that we think they would accept. That's what we do. It's not perfect by any means, but we have a broad-based membership and things are robustly discussed. And we do end up reaching a position, invariably, that is a consensus position, rather than going down the line of voting. So that's how, as a matter of practice, we try to work out whether or not there is a public interest in disclosure of confidential patient data for the purposes of enabling research to take place. Yes?
What is the concern that once it's out, you've lost control over it?
The concern is that once a patient learns it's out, they will no longer trust their doctor to keep what they tell them to themselves.
But do you have a concern that if a commercial company is doing some research for good reasons, the Chinese wards turn out to have windows in them.
We are concerned with the security arrangements in place when data is disclosed. Those are checked, and members of the group don't check the security arrangements, but they are checked by the organisation, and there is a requirement that a certain level with the IG toolkit level 2 or an improvement plan in place equivalent is satisfied. The regulations themselves, I've only talked about public interest, and I mean there's lots of detail here that I'm not going into, but the regulations themselves make clear that data can only be disclosed to an individual that is either a healthcare professional or owes a duty of confidence equivalent to that of a healthcare professional. So when it goes into organisations, we are keen to ensure that it only goes to people who are actually contractually liable if they do anything with that data other than that which they've told us they're going to do with it. And beyond ensuring that there are contractual liabilities and penalties that will be applied if people don't follow the rules, we have concerns, but we go as far as I think we can practically to mitigate them.
So everyone, especially patients, are concerned with how with the data and who sees it, even on the research conditions.
Yes.
So in regards to that, are there legal and unlegal ways of data handling if it goes from one research unit to another, from hospital to another hospital?
Yeah, I mean, if it's going in de-identified form, one set of standards need to be met. If it's going in identifiable form, a different set of standards need to be met, namely the Data Protection Act needs to be complied with, and if it's identifiable data, it needs to be handled consistent with the duty of confidence that those who collected it owe in relation to it. So there absolutely are standards which need to be applied, and there are legal ways of doing it and unlawful ways of doing it. So, yes.
Is there any control over that, if data is being handled properly?
Well, unfortunately, there are a number of examples in the newspaper, not so much, but where things are done that shouldn't happen, and the Information Commissioner's Office is the body that's responsible for taking enforcement action against organisations that don't comply with their data protection responsibilities. There isn't an equivalent in the common law, but if individuals' data was disclosed and they learnt about it, they could sue. The individuals could sue. But from the data protection perspective, it's the Information Commissioner's Office. And I know you've got Christopher Graham coming at the workshop at the end of this, so he's the guy to quiz on that.
You alluded to a point that if information flows either via Section 251 or other identifiable disclosure and is then cleaned up or downgraded to de-identified or pseudonymized information, it could then move on to other parties in other ways more freely, perhaps even for sale, which is not anything that some or most organizations are proposing to do, but I'm talking about hypothetical legality of it. Once the information would never have flown in the first place if it weren't for the conditions of Section 251, but now secondary or tertiary ongoing uses, once they're cleaned up and de-identified, that would be legal, and if that was an unplanned, an initial condition of the disclosure.
Yes, it would. I'm not saying I like it, but in direct answer to your question, and the reason, one of the key reasons for that is a case named Source Informatics, Crown against Department of Health's ex parte Source Informatics. Any of you familiar with Source Informatics? Source Informatics was a case where GP pharmacists were receiving prescriptions from GPs, which obviously they were receiving because they needed to fill the prescription for the patients who were coming to the pharmacy for their drugs. So we're getting the prescriptions. The prescriptions had the patient's name, the drugs, the GP's name, or at least the practice name on them. The pharmacist was receiving this information, dispensing the drugs, removing the patient's name, and then passing the information about what drugs were being prescribed by what doctor to a pharmaceutical company. The Department of Health said that's unlawful, because when that's confidential information you're receiving there, and you're doing something with it that falls outside the reasonable expectations of patients, that's not why you have the information. You shouldn't be de-identifying it, and I think they were selling it on to Source Informatics. They lost. Department of Health lost. And it has an interesting case history, but at final analysis they lost. And the court said, you can't breach the common law duty of confidence if you are disclosing anonymised information. If the data is not associated with a particular individual, if it's not identifiable data, then its disclosure cannot constitute a breach of the common law duty of confidence. Personally, as an academic, I don't like that position. I intend to write something on it. I've asked in the next couple of months if anyone wants to help. I'm a little bit behind schedule, but that's where we are.
So the doctor is not anonymous?
No, the doctor's not.
Is not intended to be anonymous, as it were. As far as the law is concerned, the doctors are public.
The
doctor's
prescribing habits of the doctor wasn't confidential information. It didn't have the quality of confidence about it for the disclosure to constitute a breach of the doctor's, a breach of confidentiality in respect to the doctor.
What if it had implied wrongdoing on part of the doctor? Would it then satisfy confidential information about the doctor?
No, because there's no confidence in an inequity. I can't claim that you're finding out that I've done something wrong. The fact that I've done something wrong makes the information confidential. I can't claim that you owe, because the common law duty of confidence is rooted in public interest, ultimately, and the courts won't say that there's any public interest in respecting that confidence. So, right, okay, let's try and get this back on track and try and wind things up a little bit, because I recognise we've been going on for quite a while now. Right, so I wanted to try and explain to you how the confidentiality advisory group approach working out what a public interest is. And then I wanted to move on and consider how the idea of public interest might be developed and what that might mean for access to genetic data in other circumstances. I wanted to talk to you about a particular piece of research I've done, an empirical piece of research, which compared preference to acceptance when it comes to models of consent. It's a paper which isn't published. It's been submitted for publication. If you are interested in that, the difference between preference and acceptance, because I'm trying to tease out this notion of acceptance rather than preference as being key to understanding public interest. Contact me, I'll be very happy to supply the paper or discuss it with you afterwards. But I'm going to skip over that now and move on to the theoretical bit. Because as a member of CAG, I have to say I'm very proud of the work that CAG does, and I have very great confidence in the recommendations that CAG makes. I am also aware of the fact that we work to an idea of public interest that is in some ways little more than a rule of thumb. What do we intuitively think people would have reason to accept? What would people accept as reasonable? And that's partly why I did some of the empirical research that I've just skipped over, because I wanted to see, well, what do people accept in practice as appropriate access? And I also wanted to move on to consider how the concept of public interest might be developed with this idea of acceptance, rather than simply doing what people prefer, but doing what we think people have reason to accept vis-a-vis research access to their data. And I'm trying to develop and unpack this idea that the public interest can only be said to be protected by public decisions on laws or regulations or whatever that members of the public have reason to accept. I start within this argument trying to defend the claim that both maintenance of a confidential healthcare system and improvements in healthcare are common interests. I don't think that's particularly contentious, but I think it needs defending as a claim. I then move on to try and say that as well as there being these common interests, within our society there is commitment to a common value. The common value specifically being the idea that individuals in a society should be respected as free and equal members of that society. And then the argument is about trying to see what can be made of simply putting together these two common interests with this common value when the interests come into conflict. And I want to suggest that the optimum result is the available alternative, because not all alternatives are available, but the available alternative that both minimises interference with the common interests and reconciles the remaining interests, reconciles remaining conflict in line with the common value. The interests and values themselves, I think, can be defended through this notion of public reasoning. Okay, I draw upon the notion of public reasoning and the notion of public reason. So if you're interested in public reasoning or public reason, I want to hear from you because I want to develop this argument. Okay, but I think the ideas of common interest and common value can be defended through public reasoning. I then want to see what can be extrapolated or what can be said to be entailed through acceptance of common interest and common value through public reason. So I want to suggest that recognising that individuals are free and equal members of society means avoiding, insofar as it's possible to do so, avoiding imposing upon them solutions that they themselves don't have reason to accept. Now, hopefully, people will actually accept, in fact, the reasons you offer. And a big part of the empirical work I did seems to suggest that people will accept access that isn't ideal. They will accept models of access that are not their first choice. They will accept opt-out when they would prefer opt-in, as long as you give them reasons for it, and reasons that they recognise the validity of. Ideally, we will be able to offer people reasons that they do accept in fact. And if we do, then we promote the legitimacy of the system and the decision making within it. But even if they don't accept them in fact, I think we should be transparent in our attempt to make decisions on the basis of principles they have reason to accept, unpacked in the Rawlsian and Gaussian concept of public reason. And this may involve relying upon kind of transcendent reason and seeking to identify what individuals ought rationally to accept given a commitment to these common interests and common values. But it will avoid imposing any detriment upon individuals that we don't think we can demonstrate to them as individuals that they have reason to accept. And as such, it rejects a utilitarian kind of approach towards unpacking and understanding the notion of public interest. I think that in this particular case, the case of health research, a respect for individuals as free and equal implies a relative ordering of privacy and health improvement that allows access when it is going to improve the common interest in healthcare, as long as individual opt-out is respected, thus preserving an individual's net options. Okay, that's a much bigger idea than I really have time to properly unpack. But I think it is an idea of public interest that could be taken up in the context of genetic research. And I think it's an idea which ought to be taken up even if consent is sought, if it's broad consent that's being sought within the context of the provision of care and treatment, because of those constraints that apply within the context of the clinical context that don't apply in other research arenas. I think it's the only way that we're going to be able to maintain public confidence that the disclosure of data under broad consent is going to be consistent with their reasonable expectations. I think we have to avoid allowing uses of data that would be detrimental to individuals, and that means data even if it is in aggregate and anonymised form. Because the risks which we face as we move forward, there are risks which we face in relation to identifiable data and people finding out things about us. But I actually think they're dwarfed by the risks we face as a society with the stratification of us into different groups and the treatment of us as members of different groups on the basis of information that others have about groups. And so I think the public interest needs to ensure that the detriment is avoided at both the individual and the group level. So I think the law is currently lacking in its regulation of genetic data and its use for research purposes, insofar as it draws this bright line distinction between identifiable and anonymised data. I think risks of future association mean that we ought to take very seriously this question about how we control the onward use of data, which is why one of the reasons I'm not very happy with source informatics. I think one of the advantages, I've nearly finished. I think one of the advantages, I think one of the advantages of beginning to think about public interest in this particular way is that it casts a particular kind of light on the relationship between privacy and public interest. I don't think individual and public interests are necessarily at odds in the way in which they're often portrayed to be. I don't think they are locked in battle or opposite ends of a balance or set of scales. In some ways, I think the difference between privacy and public interest is a purely aspectual difference rather than it being inherent or a necessary one. I think, therefore, it's perfectly plausible for us to try to develop an understanding of public interest which recognises there to be a public interest in the protection of privacy, and that recognises that individuals have a private interest in maintaining the conditions which are necessary for a particular kind of public benefit, such as we'll realise through health research to be realised. And so I don't think privacy is dead. I don't think privacy is any more dead than the public interest is dead. For me, and again this is something we might want to discuss, privacy is about norms of exclusivity. Privacy isn't just about keeping people out, it's about letting people in but controlling who comes in and who doesn't. As we allow our data to flow, we don't give up our privacy. We need to assert it. We need to say, just by allowing you access to this information, I haven't surrendered my privacy. I have given it to you with certain expectations associated with its use. If you then go on to use that data in ways which are inconsistent with those expectations, you have violated my privacy. And that isn't, so when people talk about kids putting all their data on Facebook and how that demonstrates they don't care about privacy, I think that's nonsense. And there's some studies which I think support the idea that's nonsense. When kids put stuff on websites, they do so thinking that there's this thing called the state or the thing called law which makes sure that nothing bad is going to happen with the data they put in there. There is just this trust, this faith, this expectation that we live within a fairly well-regulated society, and if I'm able to do it, it must be okay. That's not about surrendering privacy. That's about having a certain set of expectations about what can and will be done with your information. But I don't think that's just about privacy. I think that's also related to a notion of public interest, because I buy into this idea of privacy being constitutive and the flows of information within the society actually structuring and establishing a particular kind of public and a particular kind of society. So I'm sorry, I've lost the slides now as well, all over the shop. So essentially, I think my bottom line is that within this space, we have to work, and there's work to be done, we have to work to ensure that we do what people reasonably expect, thus respect their privacy, but we also do what we think they have reason to accept, and that's about protecting the public interest. And I think there's a gap at the moment between what people reasonably expect and what we think they have reason to accept as being in the public interest. And I think the work for us is to close that gap, to ensure that when disclosure is in the public interest and we think persons have reason to accept it, that they also have reason to expect it. Okay, thank you. So I jumped around a bit there towards the end, but I was a bit worried about the time. So hopefully it was still coherent. Thank you.
Thank you very much indeed. So, anyone like to start off the discussion? If not, I have one question. It seems to me much of what you've talked about, it really concerns an implicit contract between two parties, the giver of the information and the recipient, or maybe more than one recipient of the information for a particular purpose. And there's a sort of implied contract there of what that information is to be used for. But one of the things which perhaps complicates that model when you talk specifically about genomic information is that there are now more than two parties to the contract. Because when I give you a piece of my genomic information, I'm actually also giving you information about my siblings, my parents, my children, who are not in fact parties to that contract. Do you think that's an important issue? And if so, how do you see the law evolving to address this question of people's information being given even when they're completely unaware of the fact that the information has been transferred?
I think it is an important issue. I think it's a problem with the way in which the Data Protection Act has been understood. The Data Protection Act has been understood, at least in this country and I believe in others, in ways that mitigate against recognition of or inconsistent with recognition of multiple data subjects in relation to a specific piece of data. I don't think that's necessary. I think there is scope within the directive and there is scope within the Act to recognise that there may be multiple data subjects in relation to a particular piece of data. That would be my preferred approach. So that's how I think the law ought to develop. Whether it will develop in that way, I think is highly unlikely. We seem to be locked into this idea that personal data is data about an individual, and we don't seem to recognise that it can also be data about many other individuals too, and they may have certain legitimate expectations in relation to it. So.
I have a question about aggregated data.
Yes.
So some of the medical data is obviously published in aggregated form, and there are some statistical techniques to basically make that a little bit more individual again, like small area estimation, spatial micro simulation. What do you think about that from like a privacy point of view?
I think there's two things. I think the first is that we have for too long focused upon content and not paid sufficient attention to context when determining whether data is identifiable or not. So I think part of the problem stems from the fact that we have had this fairly narrow view of what makes data identifiable, and we've said or thought that you can come up with this list of data items that represent identifiable data items, and then you've got this list over here of data items which are not identifiable data items. And this is okay to publish these, it's not okay to publish these, which is nonsense. Because you can't say that any particular data is identifiable or not absent context. As soon as you recognise context is significant, it becomes much more complicated. And there is no such thing as perfectly identifiable or perfectly anonymised data. Everything sits on this continuum between. And again, we have an issue with the law pretending that there is this binary distinction when in fact we have an analogue one, which the law doesn't reflect the reality. If, however, we move towards recognising the reality, then I think there are two things we need to do. One, ensure that context is appropriately controlled, so that even if identifiability is theoretically possible steps are taken to control context to prevent it happening. And in that case, we recognise that regardless of the content, we have effectively addressed the question of identifiability. And in those circumstances where we can't control the context because we've published it, then we have to recognise that the data is, there is the possibility there of identifiability, and we need to recognise that as soon as we can, so that we can tell people that who we're getting the information from that we can't guarantee anonymity. So it's just about being as clear as we can be about what the reality is and letting people make choices based on what the reality is rather than being guided by some kind of fiction which the law constructs that there is this straightforward distinction between anonymised data and identifiable data, and we can treat anonymised data in one way and identifiable data in another, and we can be confident where data sits in relation to that binary distinction. It's just not true. And I think perpetuating that myth has caused all sorts of problems when it comes to providing people with information, because suddenly researchers don't think they need to provide information if it's anonymised data. So yeah, I have a whole bunch of problems with the way in which the law treats anonymised data and the way in which it suddenly seems to think that because data can be associated with more than one person, we don't have any... Okay, if data's about one person, we need to be really careful about how we handle that. If it relates to 5 people, well, is that what? No, if we cared about it when it related to 1, surely we should care just as much, or maybe even more, if it relates to 5. So, did that answer your question? Sorry. Okay.
Could I ask you a question along the lines of whose data are they anyway? So, is my genetic data always my data, even if you're handling it? And depending on the answer, and related to the answer to that question, if I generate data by the way I respond to the blue tablet, which by the way might be drug or placebo, I don't know, is that still my data? Or do those data become the data of the researcher or the drug company?
I'm not a property lawyer.
So this is a property law question then?
I think if you're asking the question of ownership, and I think you're asking a question of ownership, then I think it's a property law question. And I don't think it's a straightforward... I'm not a property lawyer, but I don't think a property lawyer would have a straightforward answer. But I think the little I do know about property, we have certain expectations of control in relation to things which we own, such as the right to dispose of it, that it may not be appropriate for you to assert in relation to genetic data I hold once you've given it to me. So I think what we need to think about is what are the entitlements that you either have or ought to have in relation to the information, and maybe strip those down and say, well, what controls should you have over the information, and not assume that all of those which are typically considered to carry with ownership are appropriately applied in the case of genetic data. So I'm not sure how clear, in my head there was a clearer response than the way I felt it came out, but does that in any way help?
Well, if the response is consult a property lawyer, I will, but I sort of... that was helpful, thank you, yes.
I mean, on this, I think you have the situation of whether other people's intellectual property is involved. I mean, you have, for instance, database rights, which are given by a directive of the European Union. If they've been compiled in a database, your individual data is still yours, but the database, the right for having compiled that is to someone else. And something else that I think is interesting as well, I think property law is relatively nuanced. You have things like architectural monuments, masterpieces of art, just buildings in an area of national preservation that you can't do whatever you want with it. But someone else also can't do whatever they want with it, so it's your property. So I mean, I think to some extent you can conceive of the genetic data as property, and in fact the ILVIS report led by President ILVIS of Estonia for the European Commission, they said your data, your decision, it's yours, but with these nuances. But I think it's a little bit of a challenge to people here today and others, the bodies, to do more research and to develop it further, also in the context of the adoption of the new data protection regulation, whenever that may be in 2015, which now has health articles and research articles, which will end up in some drafting form being adopted.
Yeah. I agree.
This is a seminar series on genetic data. Does the law at any point distinguish genetic data from any other sort of medical data? Or is it all lumped together under
Health data. The law that I am concerned with does not treat genetic data differently. I should point out that the regulation that's just been referred to, the EU data protection regulation that's been proposed, does for the first time include genetic data within the list of sensitive data items. So there is specific mention of it, but specific mention is to say it needs to be treated in the same way as other sensitive data items. So again, it's not about treating it differently, it's about making sure it gets treated the same as other sensitive data items.
Because I know at the very beginning, when the question of genetic data came up, you said, what a spectrum this is.
Yes.
From noticing you're a male to having 3 terabytes of paper tape.
Yes. And I often take that, I make that point because I'm often asked about the identifiability of genetic data. And I'm often asked a question about whether genetic data can ever be anonymous or anonymised. And I just think it's an impossible question because we have to know what we're talking about when we talk about genetic data to start with. Because if we're talking about XX or XY, if that's the genetic data, well, yeah.
Pretty public.
But if we're talking about 3 billion base pairs, well, do you know what? I still would argue that that's not uniquely identifiable because one still needs the lookup list, one needs the context. One can't focus upon content alone and determine its identifiability. But I recognise it's more, there are more conceivable circumstances within which that is going to be uniquely identifiable with an individual than other kinds of genetic data. So we have to be a little bit more specific in our use of the terminology, I think, when we're asking questions like that.
I mean, I think they're very nervous if the politicians start to worry about the nuances of genetic data. It's not their business. We don't know it. I think to say it's health data is probably a far better approach.
It's a, I mean, I had a book published, I don't know when, this year I think, maybe last, I think it was this year, on genetic data. And I started writing a book on genetic data and I got halfway through and I thought, why am I writing a book on genetic data? I wish I wasn't. And in the end, I ended up writing a book, it's still called Genetic Data, because that's what I was writing about. But all the way through the book, I'm saying, look, I'm talking about genetic data, and I think genetic data is an excellent example of the point I'm trying to make. But let's not think the point only applies to genetic data. So I think there are things about genetic data that make it an excellent example to demonstrate a whole host of things. But then we also need to recognise that those things often, I would say, invariably apply to other types of data too.
Well, I think on that note, we must bring the discussion to a close. Thank you very much indeed, Mark, for being our dragoman through this thicket of legal considerations. And I know I've learned a lot this evening, I'm sure others have too. So thank you all for coming, and we'll look forward to seeing you again in a couple of weeks.
Thank you. Thank you.